The Massachusetts Supreme Court heard arguments last week in two OUI serious injury cases or greater. These were cases involving at least serious injury. In one of the cases, there was death. Commonwealth versus Zucchino and Cappellicci from the Framingham District Court involved basically the same issue. So under the law, the Massachusetts OUI statute states that consent is required for a blood draw and blood testing. However, the statute references the first offense or sort of simple OUI offenses. So OUI serious bodily injury, OUI manslaughter, those heightened OUI offenses are in a different part but similar, closely related provision of Massachusetts OUI laws. But the government argued because it wasn't specifically referenced, the legislature did not intend to require consent if you had a serious injury or even an OUI drugs. And they get that argument because their argument is that the legislature wanted to give defendants less protections when there was an injury of victim. The idea was the law was designed to protect the victim. The defense in both cases argued that these statutes should be read as a whole, that it really doesn't make sense to give a defendant charged with a lesser crime more protections than someone charged with a more serious crime. So the idea is that the statute should be read as a whole. There's sometimes provisions in the OUI statute that aren't referenced in other provisions, and the legislature intended essentially to relate all of the statutes. In one of the cases from Framingham District Court, Judge Kunis suppressed the blood test results, finding that it wouldn't make sense. He agreed with that argument that the statutory scheme should be read as a whole, that it's sort of illogical to give a defendant greater rights who's charged with a less serious offense. However, he did state the statute was unclear and sort of indicated that he felt bound by the Moreau decision from the Massachusetts Supreme Court, finding that consent is required. The Moreau case did leave that issue open, and that's where the Commonwealth sort of went after that issue and has pursued that aggressively, stating that maybe the court suggested maybe there was a distinction between an aggravated OUI and a simple OUI offense. But now the issue is squarely before the court. In two cases, they're going to address it. One of the interesting things about both cases is that they said, well, both cases there was blood testing at the hospital. So the blood was tested at the hospital, then brought to the state police lab. During arguments, it was said that Judge Kunis said, well, this doesn't really make much of a difference because you got the blood results from the hospital anyway. The government argued, well, we want both results even though we can get this evidence in through other means. The state police test is going to be more accurate, more precise. Generally, when the state police test blood, it'd be gas chromatography, and that test can pick up drugs. So that's why the prosecutor in the case from Framingham argued that in an OUI drugs case, consent is not required, as the legislature didn't specify both OUI alcohol and OUI drugs. So when the court decides these cases, I think they'll take the logical approach that the legislature really didn't intend to carve out different rights based on different types of OUI offenses, and certainly wouldn't have intended a distinction between OUI first offense alcohol and drugs. These statutes should be read in unison as a whole to provide the same rights regardless of the level of OUI offense, whether serious injury or, as what was referred to in the argument, sort of a simple OUI, a basic OUI offense. So if you have a case involving a blood test, keep these issues in mind. The decision will probably come out in May, potentially May or June, defining what rights someone has when charged with an OUI serious injury, and whether that consent provision applies to every type of OUI offense. The idea behind the consent provisions, we don't want, and the logic applies whether it's a simple OUI or a more serious OUI, we don't want a nurse, we don't want forcible blood draws. It's not, somebody can get injured, it doesn't respect the privacy of the defendant. And it kind of creates a confrontation. It could create a confrontation at the hospital setting. So that was the logic of the Moreau case when they said consent is required. The statute is clear that it is requiring consent, and the legislature could have logically thought that defendants should have this right of privacy that you must have consent before drawing someone's blood. If you are charged with an OUI, questions about Massachusetts OUI law, feel free to call me. My name is Mike DelSignore. My passion, helping people charged with OUI offenses. I've been doing this for over 20 years. If you have a question, call, text anytime, 781-686-5924, or you can reach out on any of the social media channels, and I'll gladly answer your questions.